All rise. Term of night county court is back in session. Please be seated. Okay, the record will reflect that we're back in court on the matter of People versus Sarah Ferguson under indictment 2015-392. The defendant is present with counsel. The district attorney is present. The court is about to announce its verdict. In doing so, I am not obligated to give any explanations for my decisions, but in this case, I feel that it is somewhat important to explain the court's thinking and reasoning. I am going to keep my remarks brief because I am cognizant of the fact that we have 6 more cases to go in this. So I think Mr. McNamara had an excellent idea when he turned the indictment around and he considered the charges from back to front, so I will also follow that format. As to the defendant's accusation for the 2 crimes of gang assault in the first degree, under counts 12 and 13, the court makes the determination that the evidence has established beyond a reasonable doubt that 1, Sarah Ferguson caused physical injury to Lucas and Christopher Leonard, 2, that she did so with the intent to cause serious physical injury, and 3, that she was aided by 2 or more persons actually present. Therefore, the court finds the defendant guilty of counts 12 and 13, 2 counts of gang assault in the first degree. The court determines that the evidence has established beyond a reasonable doubt concerning the 2 crimes of 2 counts of assault in the first degree that, number 1, Sarah Ferguson caused serious physical injury to Lucas and Christopher Leonard by means of a dangerous instrument, and 2, that the defendant did so with the intent to cause serious physical injury to Lucas and Christopher Leonard. Therefore, the court finds the defendant guilty of counts 10 and 11. On the basis of those 2 guilty verdicts, the court will not consider the lesser included offense of assault in the second degree with respect to each count. Moving on to the manslaughter in the first degree charge, under count 3, the court makes the determination that the evidence has established beyond a reasonable doubt that, number 1, Sarah Ferguson caused the death of Lucas Leonard, and 2, that she did so with the intention of causing serious physical injury to Lucas Leonard. The court finds the defendant guilty of count 3, manslaughter in the first degree. The guilty verdict on this charge will mean that the court will not render a verdict on manslaughter in the second degree or criminally negligent conduct. The first count is the charge of murder in the second degree, and anyone that was here this morning and after the discussions with counsel, understood that the court had a concern with the element as to whether or not the defendant was aware of the risk of death for Lucas Leonard. The court had examined the trial testimony, and I started with the testimony of Christopher Leonard, who said during his testimony that the defendant, Sarah Ferguson, never checked on him after the beating was over. The court does not feel that there's any proof in the record that she knew the extent of Christopher's injury. I've also looked at the testimony of Grace Leonard, and she testified that after the beating, she did not believe that her brother's life was in danger. She did not perceive that a grave risk of death existed at that time. I examined the testimony of Bruce Leonard, and he testified that there was no discussion of getting medical treatment for his two sons after the beating took place. He did not think that they needed it. He testified that Lucas was walking around and talking after the beating. When he checked the bleeding on Lucas's penis, he testified that Debbie Leonard and Tiffany Irwin were present. He did not say that the defendant was present at that time that he checked the injury. Sarah Ferguson, although I did not believe very much of her testimony, she also testified that after the beating, she saw both boys standing and they looked okay to her. She did not think, she also testified that she did not think that they needed medical attention. So the court is left with the evidence before it, saying that when this beating was completed, there is no evidence in the trial testimony that anyone, including the defendant, thought that Lucas would or could die. Dr. Stoppacher testified as to the amount of internal bleeding and how instrumental that was in causing Lucas's death. He testified that the victim was dehydrated from the loss of blood, that his salt level was lethally high and it shut down his kidneys. The defendant and others caused this to happen, but there is no proof that this defendant knew what was happening internally to Lucas Leonard. It has been proven that this death was a slow process. Dr. Stoppacher testified to that fact. As pointed out by the people, the amount of blood on the pants is persuasive, but this did not happen all at one time. There was as much going on inside Lucas's body as there was outside that eventually led to his death. There has been no proof in the trial testimony that the defendant witnessed Lucas's collapse, his bleeding that required others to put a tarp underneath him, or his incoherent statements. The people suggest that the defendant was only 60 feet away and therefore had to know Lucas was deteriorating. There is nothing in the record from the prosecution or defense witnesses that proves this allegation. The court does not feel that there is proof beyond a reasonable doubt that this defendant was aware of the risk of Lucas's death. And under the law, there are a number of elements, and the people have proved each and every one of those elements in the court's estimation, but this single one, that the defendant was aware of the risk of death. Therefore, the court must find the defendant not guilty of the first count of the indictment, murder in the second degree. Now, I would point out for those in attendance in the news media that the defendant has been convicted of 3 Class B violent felony offenses. Each and every one of those are punishable by up to 25 years in state prison. The court will make that determination as to what is appropriate a sentence at the time of sentencing. I know that the media has many questions for the district attorney's office and probably Ms. Whitman. And right now, it's probably safe to assume that both sides are not happy with my decision. I am going to continue the gag order at this time, and I am not doing that because I am afraid of criticism of my decision. I am doing that once again because we have 6 other matters to take care of, and I am afraid that any statements made by the council could affect the court's ability to conduct the trial here in Oneida County on the remaining charges and the remaining defendants. Once this case is all over, you can talk to the district attorney, you can talk to defense counsel, and they are free to criticize my decision all they want if they do disagree with it. But I can't allow them to talk to you now, again, for fear that it would jeopardize or taint the other criminal defendants. So I will tentatively schedule sentencing for Thursday, September 1st. Any problem with that? No. Any problem with that, Ms. Leonard?
No, it's okay, Rob.
Okay. I will then tentatively schedule sentencing for Thursday, September 1st at 9:30 in the morning. Ms. Ferguson, somebody from the probation department will come up to the jail to speak with you. Please cooperate with them so we can come back to on that date and approve the sentence. All right, court will continue.